Ladies and gentlemen, boys and girls, and co-parents of all ages, this podcast is for you. Introducing and the center ring, the amicable divorce expert, Judith Weigel.
I always like to open each episode with some circus references because I loved my days with the circus, and somehow these references make a whole lot of sense for divorce. Our part 2 of the Erika Jayne, Tom Girardi divorce has a gaggle of these circus references that are just perfect. For instance, dealing with the lawsuits and bankruptcy is like putting your head in the lion's mouth. Going in for depositions is like walking a tightrope. And everything involved in a normal divorce is tantamount to engaging in an emotional juggling match. This just makes it more things to juggle here. So last month, we discussed the bankruptcy case with forensic accountant Lorna Mooten-Riff. And today, we're going to discuss the divorce with our resident celebrity divorce expert, attorney Matthew Smurda. It's so nice to have you back, Matthew.
Likewise, Judy. Great to see you again.
I just want to make a footnote here. So when we use celebrity divorces as our topic, it's not to judge, but to learn about the aspects of a divorce case through the prism of a celebrity divorce, which just has kind of added fun parts to it. But again, never to judge, always to learn. With that in mind, we have a lot to learn today, Matthew. So I'm going to start at the top.
Sure.
Bankruptcy and how it influences or affects a divorce settlement going forward. How do you juxtapose?
So it's a great question. I'll have to preface this with I'm not a bankruptcy attorney, nor am I a bankruptcy specialist. However, it is a somewhat regular occurrence for bankruptcy to rear its head and raise its head in the context of a divorce case. And when you think about it, it makes sense because people have accumulated debt that they now can't pay, and they have 2 households to support instead of 1. There could be other extenuating circumstances. There could be some kind of a judgment that led to the divorce, or loss of income, a failure of a business, all kinds of different things. So they do intermix with one another on somewhat regular basis. I will say this, there is under the California Family Code, generally speaking, authority that when a bankruptcy is filed, the family law case is essentially put on pause. We call it the automatic stay of bankruptcy. And it really just means that everything kind of stays as is in the family law case as it pertains to the estate, because there's so much uncertainty that's happening in the bankruptcy court. And it makes sense to let the bankruptcy court do its thing, figure it all out, and then once the bankruptcy closes, is discharged, is dismissed, whatever might happen, once it's over, then things revert back to the family law court. So that's how it works for most people, and in fact, all people, regardless of whether they're famous or just your ordinary folks.
Thank you for that. And I think that's really important because it's happened quite enough times that people come in and there's just a preponderance of debt. They're considering filing bankruptcy, which they often think is a great idea because how do you pay it all back and do child support and spousal and pay your own bills and live a life? And so I learned years ago, and thank you for endorsing this, that if it has to happen, you may as well have it happen first if you can choose, because then you'll know what you actually have left, right, to divide in the divorce case.
That's exactly right. And, the stay doesn't apply to every issue. For example, if they have minor children together, all the issues of child custody can still be litigated. It's not like filing a bankruptcy is going to put that on pause. So the court's not prevented from doing that. And in fact, the court can still actually even dissolve the marital status. We call it bifurcation of marital status. Once certain appropriate thresholds are met and requirements are met, the court can dissolve the status of the 2 parties from married back to single. And so they can become, quote unquote, divorced. And the court then it's called reserves jurisdiction over the property issues. where the court then has the ability to come back and deal with those things once the bankruptcy is over. So there are certain exceptions, and there's other things too. There's other exceptions to it. But generally speaking, when you think of dividing up the assets, dividing up the estate, who gets the house, who gets the, this bank account or this retirement account, all of that gets put on pause.
Isn't it tough, though, when people want to get a status-only divorce to come back at some point and deal with the aspects of the tangible settlement, the assets and debts? Where's the incentive for people to come back and deal with it if the divorce itself is already granted?
That's a valid point. And I would say the incentive is to get half your stuff. People generally want to get half their stuff, so they're willing to put it forward. But I certainly acknowledge that it's adding another complication to an already complicated process.
Yeah.
It does not make it easier. It does not. And again, we could spend a whole episode going into
which maybe we should at some point, because I get enough requests for bifurcated divorces, and I've never done one and I won't do them. I really do refer out to attorneys for that. For some reason, it seems too complicated for me. But I get enough phone calls saying, we got a status-only divorce. I can't get him or her to come back and deal with the assets and debts. Do you get that too?
Occasionally, yeah. I mean, it's going to depend on the estate and who's asking. Certainly, for example, and this is somewhat of a hypothetical, somewhat based on real experience. I had a case where this couple did the status divorce and even did some but not all of the property, divided up some assets but not all of it, back in, I think it was in the late 1990s. And about a year and a half ago, came to see that in the judgment, they agreed to kick the can down the road, so to speak, on this one condo that they owned in the San Fernando Valley, where one of the spouses was living. And in their document, they indicated that they would plan to dispose of that within about a year of the judgment. So you would have expected them by the year 2000 to have dealt with that. Well, here we were this was in, I believe, late 2019 or early 2020. And guess who's still living in the condo? Title still held the same, husband still living there. The mortgage had been paid off and nobody dealt with it. So there's a real example. You're talking 20 years almost of delay, and neither of them did it. And the one who wanted to was my client, who wasn't getting to live there, but was entitled to half of the equity, which, as you can imagine, a condo in the San Fernando Valley certainly appreciated in value from the late 1990s to the present. So that's just an example of how I've had that exact issue come up. And so I get it too. I mean, nobody really likes doing this stuff when they're going through it as litigants. Nobody really wants to go through it twice, let alone once. So I think the point is well taken that, it certainly could slow things down. However, where I see people want to bifurcate status the most, number one, they want to get remarried. And their new spouse to be doesn't want to wait for the divorce to shake out. Number two, if there's some kind of urgent health issue, I've had it come up in that context. And they want, for a number of reasons, they want the status to be dissolved, including but not limited to the potential impact that could have on whether the, I hate to be morbid, but the probate proceedings would play out in the probate court, or if they'd play out in the family law court, how the death may impact the distribution of community property under probate law, all of those things. So those are the most common circumstances where I see it.
Well, in the Erika Jayne, Tom Girardi divorce, the bankruptcy, we'll see if they do status only, Matthew. Who knows? There's so much going on here that we have to get to, but that play into this. So the bankruptcy was filed in March of 2020. The divorce was filed in November of 2020. Depositions were requested of Erika May and September of 2020, but she didn't sit for them. And there's no explanation in anything I've read. People Magazine happens to be my source for this particular episode because there were so many articles they released on this. But this brings me to another story in the news that I assume can happen in other cases, and that is the divorce was called an alleged sham to protect assets gained through alleged misuse of client funds or law firm funds from Girardi Keith Law Firm, her husband's partnership law firm. So why would that statement even come out? How does this work that there's a bankruptcy, there's an alleged malfeasance of money in the business that supported the marriage, and can assets be protected if that's the intention by filing a divorce and freezing community property if in fact the assets were purchased from misuse of funds?
I think that is going to require a very long explanation. Let's work backwards.
Okay.
So I think what the allegation is that the divorce is being used essentially as an asset protection vehicle, right?
Well said. Yes.
Okay. And so the theory behind that, because look, people are very creative when it comes to protecting themselves and protecting their money. So certainly, I've heard in the course of my career, people have this idea that they can do either a divorce or a legal separation in which the paperwork is all done properly and a judgment is issued. Usually it would be what's called a stipulated judgment, meaning they reach an agreement, and per their agreement, things are divided up. Assets are divided up, debts are confirmed. Okay? Now, in theory, what they believe is that, for example, we have to use a hypothetical for this. So let's assume there was a couple that wanted to use divorce or legal separation as an estate or an asset protection or an estate planning vehicle, either or. And let's say they owned a business and they owned a house and they owned 2 cars and a bank account. And the business is failing and has all this debt, and one of them is personally liable for the debt. Maybe they had office space, whatever it might be. But they don't want that debt to then be subject to and used to seize their other assets. They don't want to lose their house. They don't want to lose their bank account. They don't want to lose their cars. Okay. So this hypothetical couple, what they could do in theory is they could reach an agreement. Let's assume they're a male-female couple, husband and wife. Let's assume the husband is the operator of the business. Okay. So let's say husband and wife agree that husband gets the business and is responsible for all debt associated with the business, and wife gets the house, the 2 cars, and the bank account, and there's a waiver of support, and they walk away. Everybody's happy. Okay. Now, in theory, and we're looking at it very simplistically, it is possible that as soon as that judgment is entered, those assets are confirmed to wife as her separate property. But here's the problem. Number one, the judgment would not be binding on creditors necessarily. Just because these two make an agreement, they can't cut out the creditors who are relying on the contract that they had for these debts. So that's one thing. The judgment may or may not be binding on the creditors. And a lot of times in our judgments, we even put language that says, for example, this judgment's not binding on the IRS or the California Franchise Tax Board, because they can do whatever they're permitted to do under their rules and regulations when it comes to enforcing a debt. Same thing goes if there was, private debt owned to a bank or whatever it might be. So that's one complication. The second complication is if the creditor finds out about all of this and feels it's not legitimate, it's not a good faith divorce, that this is being done for asset protection, the creditor may have rights to go to court and essentially seek to bypass or set that judgment aside. Now, again, I don't practice this area of law. I can only give you kind of my ground level understanding of it, but essentially what they could in theory do, I understand it would be what's called a fraudulent conveyance claim, where they could make a claim that this divorce was a fraud. It was being done to defraud the creditor. And then if they can prove that, and I don't know how to do that because I don't litigate that, but if they can prove that and satisfy whatever you need to do, that should in theory let them bypass and the divorce and go after both of the spouses and go after the assets. So that's a big complication for it. So again, recapping on this, what you would look at is you'd want to look at contractual privity. So who are the people to the contracts where the debts came from? And when were the contracts formed? Because that's another key question. So under the family code, under the California Family Code, if a debt is the separate property debt of one spouse, then the community property can be used to satisfy the debtor's debt, and also the debtor's separate property can be used to satisfy it. If it's a community property debt, then community property is liable, obviously, right? As well as the separate property of the debtor, and in that instance, the separate property of the non-debtor as well, because it's a community property debt. The only real barrier would be if someone had separate property assets and they were not the debtor, and the debt was the separate property of the other spouse. In theory, when you have complete separate property division, we'll call it, or the wall of separate property, as I explain it, right, then you in theory have assets protected. But that's not so easy. That's not so easy to prove. It helps having this cooperative judgment in theory, but again, there's a lot going on here. It's not so simple. And I always put it, if it was that simple, everybody would be doing it and all these debts would be going out the window, and lenders would be charging even more interest to cover their risk. So that's not really how it works. People have kind of a misguided view on that, I think.
So when I first brought this news story to Lorna, the forensic accountant, who I'm in a group with her, a monthly evening group with her, I was in shock. I had no idea people could do moves like this because I do very simple divorces. Lorna does high end. She's a forensic accountant, so she sees a lot of wealth. And she said, no, like you, it's not as uncommon as you think. People try and get creative to protect assets, especially if they know they may be in question somehow. And in this particular divorce, the Gerardi divorce, because I've been reading these news stories for a month now, and of course, I watch the Beverly Hills Housewives. So I am Bible on what happened every episode since 2015 when Erika came on the show. And I find it fascinating to think back to things that were said that are kind of coming to light now. But what you said about that wall of separate property, I think you just used those words. So I think that wall has been broken down if what I'm reading is correct, and the bankruptcy court looked at this other aspect of the case being this $20 million that in portions was moved from the Girardi Keese law firm to EJ Global Enterprises, Inc., Erika Jayne's company, because she works. She's a performer. So she doesn't have Girardi Keese money, but she has money. Right. I like her music and her performance. But I guess the bankruptcy court traced purchases that the $20 million bought and now is looking for some of those assets back. And what was the other part? The $20 million and gifts. That was the other part.
Yeah. Yep.
So now we go to another piece of a community property law. And community property is California and many other states. But gifts, even during the marriage, are separate property, right?
Not always. Not always. Most of the time, yes. There is an exception you can look at if the gift is substantial, taking into account the overall relative financial circumstances in the context of the marriage. And what that means is, for example, if it was just your garden, if we're using jewelry as an example, right? If it was just your garden variety necklace from Nordstrom, or even if it was a really nice necklace from Rodeo Drive, you would have to look at how much it cost, and then you would have to compare it to the overall financial circumstances of the marriage. Because if, for example, again, this is extreme, but let's say he bought her the Hope diamond, right? You
Pretty
can't
extreme. Love that diamond.
You can't just buy a diamond like that, which is worth, millions upon millions of dollars, and then just gift it to someone, and all of a sudden it's gone because it's separate property. It just doesn't work that way. That would be essentially a form of money laundering in the context of marriage.
Would it really?
Well, if you set it up the right way in advance, in theory, it could. It could be. So not necessarily, but general rule of thumb, yes, a gift is the separate property of the recipient. And again, they probably are both going to cooperate as much as they can on that. But the problem, and I'll go back to what you said at the beginning, the problem as I understand it in this case, and again, I'm not a part of it, so I don't have any specific knowledge other than what's been released in the public. The problem with this case is I think they tore the wall down based on what they did, that separate property wall. I think they did quite the opposite. I think they did essentially what we would refer to as commingling of everything. Because what probably was happening, again, I don't have any reason to know this, but what probably was happening was things were being documented as one type of transaction, maybe for accounting purposes to minimize income or whatever it might be. But then on the other side of it, things were being done for convenience because it was convenient to move money. And then there was the whole illegal allegation part of it where they alleged that these weren't funds that he were entitled to access because they belonged to clients. So there's just all of these issues that all are intertwined, which makes it a really, really messy case to figure out. So you have to really kind of look at things issue by issue. But what I saw, for example, I believe a couple days ago, it was released publicly that on the 2018 tax return for the law firm, the Girardi and Keese law firm, there was a line entry that in 2018, there was a receivable that the firm had from EJ Global. And that's I believe it's the LLC, EJ Global LLC. And right. The California Secretary of State website identifies Erika Jayne as the manager of that LLC. So if you look at that, what that's saying is there's on the balance sheet of the law firm, there is an account receivable worth $25.3 million, which means that's the loan balance owed to the law firm from this other entity.
Oh, wow.
So on its face, those documents would appear to indicate that somewhere around that amount of money, probably plus interest or whatever it is, was loaned, because that makes it a receivable, right? Was loaned to this other entity. So that's really complicated. Why is a law firm loaning money to an entity that appears to be operated by the spouse of one of the managers of the law firm who is in a totally different industry? She's not a lawyer. She doesn't have a license to practice law. As far as we know, she's not a vendor of the firm like an expert witness or even an employee per se. So it makes it kind of odd, right? So the other variable too, on top of all of this, is I haven't seen any mention of this, but do they have a prenuptial agreement? And if they have a prenuptial agreement, how does that tie into all of these transactions?
It's never been mentioned. So my Bible, I of course will go back to the Bravo show, the Beverly Hills Housewives, and it was never ever, it may have been mentioned, but it doesn't strike me as having one, and it's not come out in any of these stories either. She is the third wife. The San Marino home, which is no longer their asset, it's being sold, I understand. She's the third woman who's lived in that home, so he's had that home forever. So I don't know, but you bring up another good point, because I was going to ask about the business. So there are a lot of questions I have about the business. In general, when there is a business as part of the estate and it's a partnership, when you go to look at that business as a marital asset, you only look at half the business. How does this work if it's two people owning?
No, it wouldn't be that simple. So this is one of the most complicated areas of divorce litigation in a normal case. It'd be valuation of a business interest. And one common misconception people have, I'll go through some of the common misconceptions, and I'll get to the one you just mentioned about how you just look at it as half or however that is. Well, no. So the first misconception, which I think would apply in this instance, and again, we're on the assumption there's no prenuptial agreement here, because a lot of times you would deal with this in a prenuptial agreement, but let's assume there's not one. So you'd first look at, okay, did the business exist before marriage? And I believe it did in this instance. He had this practice many years before marriage. So technically speaking, that interest is a separate property asset because it was acquired before marriage. Now, does that mean that she has no interest in it? Of course not. No. There's ample body of law in California, and in very old cases, actually. There's two kind of famous ones. They're called Pereira versus Pereira and Van Camp versus Van Camp. They're very famous cases. And each of them gives a different formula, mathematical formula, for how you would calculate what happens with such a business from the work efforts of the operating spouse during marriage, meaning what happens to the business from date of marriage going on? Does it grow? And if it grows, why is it growing? Is it growing because of this person's work efforts? Or is it growing because of just market conditions? Like if you owned a painting or something, you can look at it both ways. You come up with an analysis, and that formula would be used to calculate what ownership percentage the community would have in the business and the growth in the business. And then in theory, half of that would be community property. This would get more complicated in the sense that probably what's going on in a law firm is that the operating spouse's interest probably changed quite a bit as new partners came in and new shares were issued in the partnership. How revenue grew or didn't grow, if money was loaned, if there were shareholder loans back into the business when things were low, or if money was taken out for draws. I mean, you'd have to basically, what I would do is I would have to get a hold of all the different drafts of the partnership agreements for this entity and take a look at it. And you would then, this is something you undoubtedly would have to do with a forensic accountant. And you'd be working hand in hand to come up with a valuation of whatever the interest might be. And then once you have that, then you have to figure out, well, how is it going to be bought? Because essentially, in a normal divorce, if there was value to the law firm, then the operating spouse would have to buy out the non-operating spouse. In this case, it's easy. She's not a lawyer. She can't just take on a law practice. She's not allowed to do that because she doesn't have a license. So she needs to be bought out. And then there's a whole question of how that works. And so the long and the short of it is you're talking about a very long, complicated, extensive financial battle that's going to turn on having a very, very good forensic accountant to help you go through that, calculate it, present it to the court, and then how to make it work financially. Now, in this case, there's not going to be a practice to divide up because
it's
party can't practice anymore, right?
I know the law firm's closed. That's it. In fact, Robert Key, I think it's Robert Keys, and the other lawyers are actually in a separate suit suing Tom Girardi. Right. Some of them didn't get paid. Right. Still money's owed, and all of that. In a partnership, though, the thought just occurred to me. In a partnership, would one partner fear if the other partner was getting divorced?
Of course.
Normal divorce.
Of course. And a lot of times, I don't see this in law practices as much, surprisingly, but a lot of times in family businesses, in real estate development businesses, there is a requirement, whether it's officially or unofficially, among all of the partners that each of them have to have prenuptial agreements. before they get married. Yeah.
Well, this surprises me that it was never brought up in conversation or even on the show. That's where I have my conversation, or in any of these articles. And Tom's an attorney, and he was a really great attorney. So I am surprised if there wasn't one. It hasn't been brought up.
I am too. Again, I mean, you can't speak for why. I'm sure, Mr. Girardi is a very smart man, despite everything that's happening here. I mean, he's a brilliant.
He had a huge career of helping a lot of people until, the latest few years of discussion here.
Exactly. And, respected for many years as a brilliant attorney. And so he's by no means, I'm sure the thought crossed his mind, we'll put it that way. And I would be shocked if he didn't approach her with that discussion. But I'll tell you this, I have had many, many potential clients who I've consulted with and explained the benefits of prenuptial agreements, and they don't go through with them. And they have to make a choice a lot of times. Do they want to get married or do they not? And a lot of times their spouse will just say, I'm not signing a prenup. So if you don't want to get married, then and you don't trust me, then I'm out. And they don't want to lose that, And look, Erika Jayne's a lovely young woman, and for a much older man, he might have just rolled the dice on it and said, I'm just gonna do it without a prenup because I love this woman,
Conceivably, yes.
Who knows?
Well, this brings me to a couple other questions about businesses. So is it different for a law firm and a non-law firm, this issue of loaning money to a private person connected to one of the partners?
That's a great question, and I don't know the answer to it, but all I can tell you is I wouldn't loan any money in my law firm to a private person. I just wouldn't do it.
Is your wife listening?
She is. She doesn't have to. I don't have to loan her the money though. She just takes it and spends it. So she already gets it. But no, I mean, they went to a lot of trouble. This is very different than him doing things through the regular channels, receiving a salary or taking a draw from the company, putting it into a joint bank account or whatever it might be. This is very different than that. This was being presented as an on-the-books loan where money is flowing. And there may be accounting reasons for that. People play games in any kind of business where they call things a shareholder loan as opposed to a distribution. And they can take the position from a tax perspective that that's not income to them. And so this could have been part of that. It could have we don't really know. But I don't think it's a good idea at all to loan money, especially money from a client trust account, to a company that your spouse owns that is in no way related to the practice of law. It just doesn't make sense. It'd be a different story if, for example, she were a forensic medical examiner.
Yeah, a support service to what the business would need.
Right. Even if she was let's say she was a court reporter, a licensed court reporter, that would at least make sense because she could, do transcripts and things for their depositions. But, I just don't see how, putting on musical performances and things would help a personal injury law firm. It just doesn't, the two don't really equate.
Okay, so I was just kind of thinking how it could be legitimate, and I wanted to run this idea past you. I mean, I put quotations around legitimate, but it's an interesting conundrum. So would it be more legitimate if Tom himself had overpaid himself, somehow loaned himself the money, put it in a personal account with only his name on it, and then dispersed it personally to Erika? Would that have been any more legitimate or still?
Well, I think where the problem turns is, was he entitled to the money? Okay, because here's kind of how the law works. So money in an attorney's client trust account is, in theory, property that's being held in trust that belongs to the client. And it doesn't belong to the lawyer until it's transferred out of the trust account, into a business account, an operating account. And the lawyer is not supposed to do that until they've, done the work or whatever it is that the retainer agreement entitles them to on the fee. So where I think this is a problem and it kind of stops the analysis is if it's true, these allegations, if it's true that, for example, money was paid into the trust account for a settlement, and per the retainer agreement that the firm had with these victims, that money belonged to the victims. If that's correct and the money was spent by the law firm or one of its members, that's not proper. That ends the analysis right there. They're not supposed to do that.
Right.
They're not supposed to use their trust account to make loans. It doesn't work that way.
So can we just share with the audience for a minute, how does this work in a traditional law firm where you have clients and they give retainers, or in this case, a personal injury, you collect money as an award that you got from a case representing? Where does this money go inside of the law firm?
So good question. So there's two different issues there. The first one would be in this context, let's use the personal injury, right? So in most personal injury cases, and again, I don't practice it, so I can't tell you definitively, but I'm familiar enough with it. Most personal injury attorneys are going to take the case on what's called contingency, which means that they're not going to be paid by the hour for their time like another kind of lawyer would. They're going to collect a percentage of what they recover, whether they take it to trial or they get a settlement. Okay, so let's just say, let's just pick a number. Let's say 40% is what they get. Okay, but in the process, they're going to also have to advance a lot of costs. So either the client would have to give them some money to pay the costs, or they would have to pay the costs out of their own pocket. What kind of costs are we talking about? Well, we're talking about filing fees when stuff is filed with the court, because every time you file something, you have to pay money. Sometimes it's not much. Sometimes it's up to $500, depending on what it is. Let's say depositions are taken. Depositions are essentially interviews out of the courtroom, but with a court reporter, they're making a transcript. Well, the court reporter costs money. You have to pay the court reporter for the transcript. That's a cost. Let's say for a personal injury, somebody had to go see a doctor or a chiropractor or anybody who helps them. Well, either the injured person pays it themselves, or the lawyer would pay it, or these people would take a lien on the case to be paid out of the settlement. So those are other kind of costs. So just things like that, right? So at the end, when the settlement comes in, let's use even numbers. We're talking a 40% contingency rate. Let's say $1 million comes in for a settlement. Okay, so that $1 million check would go into a bank account held by the law firm. It would be called the client trust account. Okay, so that's it's kind of like an escrow account. It's similar to that. If you ever put money into escrow, it's supposed to just sit there.
Matthew, is the client trust account in the name of each client? Are there all these separate trust accounts?
It could be. There could just be one, and then it combines all of them. And as long as there's an accounting, that's fine for a lot of people. Or each one could have its own. It's totally up to the law firm how they want to do it, as far as I know. Okay. So let's just keep it simple. Let's say it had its own account, right? So they create we'll call it the Smith & Jones case. So they create the Smith & Jones trust account. $1 million goes in there. And then from there, the lawyer has to start paying out all of those costs that haven't been paid, right? So if anybody took a lien, if the chiropractor took a lien, the chiropractor gets paid. If there's stuff that hasn't been paid yet, it gets paid. Also, to the extent the lawyer had previously paid expenses with his or her own money or on his or her own credit card, they would reimburse themselves generally for what they paid. And then what's left after all of that, that's where the 40% would stay with the lawyer and the 60% of what's left would go to the client, right? That's how it would work in most. And there'd be an accounting. There would be an accounting that would go with the check to the client. And the client would be able to see, oh, okay, here's this, here's that, here's the other thing. And presumably the client would have been getting invoices as this was going on so that they're not totally in the dark as to what it would be.
Right.
You would not expect the $1 million to sit in the account and then be used by one of the firm operators to pay for other things, because that's not their money to take per se until all of that is accounted for and figured out.
Right.
So that's where I think the allegation is they're claiming that was what was being done from money in the client trust account.
I know this is going to be rhetorical, but I just have to ask it because it is part of the story. It's come out in many articles. So in 2010, there was a client, I can't say their last name, Ruagamas. There was an explosion. There was a gas line explosion in San Bruno. I guess that's Southern California. And one of the family members got very burned. And so there was a lawsuit and they got paid. Tom didn't disperse all of the money. He had said, let me invest it for you. This is more money than you're probably used to. I mean, this is in several different stories, true or not true. It's just an interesting position to look at, that this might have happened. Let me invest it for you and put you on a monthly disbursement of $1 million a month. Now, it's interesting that the family said yes. They've given interviews on this. So I guess from the family's point of view, it happened.
Right.
They've given interviews on this. And it strikes me as so important to say to the general public, what would be something, whether that would be something normal that could ever be done. And I am surprised that they went for it, but why would they? Are people are really that trusting or need help?
It's a valid question. I mean, I wouldn't say that's normal. I think what would be normal would be that money would be distributed directly from the law firm to a financial advisor if the people didn't want to manage it themselves, to I'm just using Merrill Lynch or Ameritrade or UBS or whatever. I mean, somebody like that, you would just send them the money, and that's what they do. They're an investment advisor, so they would handle the investments, or you would give it to some kind of a business manager. A CPA who would help manage and invest the money. It's unusual for the lawyer to do that, so I don't know enough about it. It just kind of seems odd to me that then there would be this arbitrary disbursement, because that's their money. The money from the settlement is their money. They should get it and be able to hold it. So that seems very odd.
It seems odd. Do you have the ability to invest? So now you're an attorney supposedly saying you have this extra ability to be a financial advisor, an investor of some sort, which has nothing to do with the practice of personal injury law.
No. I mean, you would have to look at the specific circumstances and see if there was a conflict of interest in doing that. But
Good phrase.
Me personally, I wouldn't touch that. I would just send them on their merry way and wish them the best.
But this speaks to how much the average person wants to trust their attorney.
Sure.
They really want to. They want to feel like they're being totally taken care of, even if it exceeds the boundaries beyond which a lawyer can go because it's not practicing law anymore.
Right.
You're working. Right. So I just found that so fascinating. I want to move into this other interesting aspect that affects divorce because it's not been discussed at all. So you have this conservatorship. The Tom Girardi's brother is now the person, the conservator. And this social media kind of plays into what I'm going to be talking about at the same time. But on the petition for divorce, at least in California, I bet it's similar in other states, but in California, a no-fault divorce state, you check the boxes for the reason for divorce. So one box is irreconcilable differences where 99% of the checks go, right?
Right.
And the other box that you check is permanent mental incapacity, disabling an actual relationship to function. You can talk to the person, you can do things together, you're of like mind, so to speak. So in February of this year, there was the filing for the conservatorship because Tom was having dementia going into Alzheimer's. I almost forgot. I wonder if I need to have a medical exam. So going into, on many reasons I do. So going into Alzheimer's, the court granted the conservatorship recently. What does that mean now when the divorce picks up again? What does that mean for the divorce proceeding and Erika and the ability to negotiate if there's anything left?
Well, I think that's a valid question, and I think there's a lot of what ifs there. I think that's the kind of thing that no decisions would be made until they had to be, because again, his mental state could change drastically between now and whenever the bankruptcy is over. It could improve or it could get even worse, right? So it's one of those things where having a bankruptcy stay probably would kind of table the issue, but let's play it out hypothetically. I think the first question any judge would look at is, well, does Mr. Gerardi have counsel or not? Because presumably having an attorney, having counsel, would allow the attorney the ability to make a lot of decisions, not all of the decisions, but a lot of decisions on his or her client's behalf. Now, where it gets a little more tricky, though, is how is the attorney able to do that? And I think in that instance, the burden would fall on the attorney to say, hey, yeah, I'm more than able to do this, or I can't do this. Now, if I'm more than able to do this, probably what you would assume is there's someone else who has power of attorney or has decision-making authority for the client behind the scenes, who then is acting on behalf of the client, like a conservator would, right? If that happens, then it's probably no big deal and everything just goes on. Then there's, of course, the issue of, well, can the client testify or can they understand questions? There's that whole issue too, but let's put that aside for a moment. If those things don't exist and the attorney's not able to communicate with the client, well, the attorney can't continue representing the client. And if that's the case, then the attorney would have to either substitute out by way of consent, or more likely, if the client is truly mentally incapacitated, would have to file a motion to withdraw from the case and get a court order allowing the attorney out of the case. So it's certainly complicated things.
Okay, but there's a conservator. There's somebody who will speak for
right.
the respondent. Tom is the respondent in this case. So would it be his brother, the conservator, who would speak for Tom?
I mean,
with the to Tom's attorney, whoever that is.
To Tom's attorney, yeah, probably, but not to the court. I mean, as far as I know, a conservatorship wouldn't give the conservator the ability to testify in the shoes of the client who's mentally disabled.
Okay, but, I didn't even think about that. But yeah. Okay, I get that then. I get that. Social media. So it's really interesting how social media affects court cases.
Oh, yeah.
And it certainly affects things like, I don't know, spousal support, child support, monies you're spending, places you're going, and you have it on Facebook, and then all of a sudden you say you have no money. So how can you pay for your obligations? Well, we have Erika on social, on the reality show, the Housewives of Beverly Hills, and talking about all the jets too. Yep. All the bling, all the this, all the that. You got this beautiful tour of their estate in San Marino, which I loved more than anything, which nobody's taking a tour of now except for the new owners, whoever they are. So we have Tom on social media. We have Tom on the Housewives. He's made appearances. My only question for dementia and Alzheimer's is, how long does it take for this stuff to kick in? Because it wasn't that long ago, he was part of some scenes, and he seemed to be fine in those scenes. So, I know you're not a doctor and you don't really know, but let's just talk about in general. How should people curtail or pay attention to their social media posts if they know they're going into a divorce and throughout the divorce?
So, general rule of thumb, is don't post anything on social media that you would not want the judge to read and hold up in an open courtroom during your trial. That's the general rule of thumb. Now, if you put it in this context, you're exactly right. I mean, literally, I just before we were doing our discussion here today, I was looking up on social media, and apparently recently Erika posted a picture of herself walking out of a private jet. And let's play that out hypothetically. So here's how you would figure that out. You'd try and get her to identify who owns the jet, who paid for the jet. Even if she doesn't do that, there's a little marker on the tail of that private jet. You could track down, if you have enough time and resources, you could track down the registered owner based on that tail number, just like a license plate. Find out who owns it, subpoena information from the owners. You can subpoena the flight manifest, because every time somebody flies on a private jet,
Right.
there's a manifest by FAA regulations that says everyone who is on board.
Yeah.
You can find out who is on board. You could subpoena the company, find out who paid for it, who owns it. I mean, just from a picture of somebody walking out of a private jet, it opens that door, you know?
Yeah.
Like you said, the issue of mental competence. Again, I don't know how it's going to play out, but I can tell you if I were trying to prove that he was mentally competent and that this is some kind of a false claim or a sham, I would use all that footage and I would get the dates of all that footage. And then I would show that footage to an expert who would be either a forensic psychiatrist or some kind of a medical examiner, a doctor who is an expert. And you show that to the doctor, and then you would say, you know, I think you said dementia. Well, is that what you just saw indicative of somebody who has dementia? Yes or no? What did you see? And you get their expertise and their opinion to the court.
So my understanding is there was a forensic psychologist in Long Beach that actually wrote the diagnosis that Tom, in fact, did have Alzheimer's.
Okay.
So, you know, there will be all of that going
Sure.
back and forth. But, you know, social media comes up constantly, and just a word to the wise, everybody listening, get off that social media now. Let it go. Make phone calls if you want to connect with people. It's not worth it. And it's public. There's no such thing as private, really, right? You can always.
Here's where it gets tricky, though. So I've had a number of clients who would be deemed social media influencers. And that's how they make their living.
That's how they make their living. Okay, go ahead.
And so you get into a really tricky situation where that's, you know, part of their whole persona is being real and documenting every aspect of their life. And oftentimes, if they're going through a family law issue, that's one of the biggest things in their life. They want to document it. And it becomes very difficult to have that not happen and have that not be documented, or if it is, in an appropriate way. There was a case that I had where the other side seemed to think that a tweet was referring to our judge as a narcissist. And we had to explain that that wasn't the case, because it was just a general tweet about narcissism. So there's a perfect example, right? They could take something ambiguous that uses a loaded term and try and turn it against you, make it seem like you're calling the judge that, which that wasn't what happened, but the document's there. The document says what it says, and it's subject to interpretation. So I would caution anybody, be very careful. I had another case. I'll give you, this is an example we used very well. So I was having a trial for a restraining order, and we were trying to get assigned to a trial court, which if you've ever been to the downtown Los Angeles courthouse, it's called the Stanley Mosque Courthouse. There's a main department. It's called Department 2. It's where it's the head department for all of family law cases in Los Angeles County. And it's a very, very big courtroom. It's maybe the size of like a good sized indoor basketball gym. It can capacitate a lot of people, or at least it used to before COVID. So we were sitting in this big room waiting to get assigned to a specific courtroom that was going to handle our restraining order case that day. And I'm sitting next to my client, and the gentleman who was subject to the temporary restraining order, who we were trying to get subject to a longer term restraining order, sat behind us about 3 or 4 rows. Now, why this is relevant to social media is he took a picture of the back of my head and the back of my client's head as we were sitting in open court. He circled my client's head with a big red circle and wrote some nasty things. I won't repeat them, but it was profanity and something about killing somebody.
Oh my gosh.
And then posted it on his Instagram story. Now, what better evidence was that for me, for what I was doing?
For a restraining order.
Right. So we were able, so here's how it played out. My client's friend sends her a text immediately saying, oh my God, look at his story. He had blocked her, but he hadn't blocked me. So I looked him up. I captured a screen grab of it. We walked down the hall to the coffee shop where you can print documents out. We email it. We print out 5 full-page blow-ups of the picture and the post, and we have it in our back pocket. And we used it in trial, and the guy lied. I asked him, I said, are you on social media? No. Is your username, XYZ? No. Have you posted anything today? No. Have you posted a picture of me today? No. Have you posted a picture of my client? No. I'd like to show you a document. Pull it out. Put it right in front of him. The judge's jaw hit the floor. And that was specifically cited as an act of domestic violence in the judge's decision, and we got the restraining order.
Wow.
So there's a perfect example of how social media for a lot of lawyers can be a wealth of evidence.
Yes. And you know what? You use technology very well. I was thinking as you were telling this story, dang, Matthew has to be great at technology here. So do the other lawyers, I guess, because that's the world we live in, and you have to know how to react quickly, which you did in that particular situation. You didn't need to call in a millennial stat to handle this for you.
But it doesn't hurt if you have one. If you have a really tech-savvy millennial who can work for you or help you, it's a great resource.
I love it.
Actually, not even a millennial. You have to go with Generation Z because they're the best right now.
Yes, they are. They know what all the little dots stand for in any corner of any posting.
That's right.
Okay, so I'm going to ask you a question about something near and dear to your heart, attorney's fees.
Sure.
Matthew, how are attorney's fees requested, one spouse to another, the higher wage earner pays them, and how are they granted? What's the process for attorney's fees?
So attorney's fees are an issue in pretty much every family law case. They can be dealt with at the time of trial, or they can be dealt with even at the very beginning of the proceedings. And to do it then, you have to file a motion, which we in California call a request for order. So you file paperwork and you make a presentation to the court about why you should be entitled for the other side to pay your attorney's fees. And generally speaking, what you have to show is that your fees are reasonable, you're asking for, that the other person has the ability to pay. And this isn't a requirement, but a good presentation would be that you show that you took some reasonable steps to try and avoid it, but the other side is creating the conflict. That's a really, that kind of beats
to try and avoid the hearing.
Correct. Okay. A good faith attempt at settlement or offering some kind of solution that could avoid where you're going. That makes an attorney's fees presentation, I think, all the more powerful by showing that, hey, we're doing this last resort. We tried to avoid this. We're not just trying to get a big check here. But if you can do that and you can convince a judge that there is a disparity in income or assets, the fees are reasonable, then you should be entitled to a fee award. And the fee awards can be done a number of different ways. There can be a number of bases upon which the court can make a fee order. And you need them. I mean, half the time you're representing the spouse who has less money. That's just a fact.
Right.
And a lot of times you need a contribution like that in order to do your job. And the theory is the other side, your client, should be entitled to a contribution from the other side to level the playing field so that they have access to an attorney as well. So fees are a big part of a lot of family law cases.
Now we go to the Jayne Girardi divorce case in regard to attorney fees. And if there was no bankruptcy, if the law firm was operating just fine, Erika would be the one more than likely, I would expect, to request attorney's fees, or whomever would be representing her might look to see that she has enough money. If both spouses are working, but one spouse has a lot more money than the other, does the attorney representing the lower earning spouse still say, because there's this giant inequity, we're going to ask for attorney's fees from your spouse, the higher earning spouse?
Generally speaking, I would say yes.
Yeah.
Because it's not just, you being employed doesn't disqualify you from a contribution. the judge kind of gets to look at the whole picture and make the decision if you can't reach an agreement on it.
Okay.
And the judge would look at the whole picture. Let's say, for example, you have two people. The husband earns, $150,000 a year, but has $20 million in cash. And the wife earns $500,000 a year, but lives paycheck to paycheck, has no cash. Even though she's the higher earner, she could still argue that she should get a contribution based on the amount of cash that the husband has. Yeah. Okay. So it's not just limited to income. It's the whole financial picture, income and assets.
So in this particular case, and we don't really know what they're living on, Erika and Tom, we really don't know what they're living on. He asked her to pay attorney's fees. I don't even know who his attorney is, but I guess that's possible if the law firm is closed and he supposedly has nothing in the bank and she's really still working.
It's possible. I mean, it certainly is possible. But again, the court can look at the totality of the circumstances. And I think that would be a very, very tough sell to try and say, if I were representing him, to say, hey, my client did this, did that, did the other thing. The bankruptcy court made all these findings. He lost all his money. She kept working. She kept it together. So now she should have to pay his attorney's fees to me. I think that's a tough sell.
Is it? Okay.
I think that's a tough sell, just from an equity perspective.
The other way around, she actually asked for him to pay attorney's fees.
Of course. It's very common for both sides to ask in their, and where I think you're getting this from probably is in the petition and the response. It's very common in the petition and the response for people to do that, for one side to ask that the other pay the attorney's fees, and the other one says one side says the other should pay spousal support, the other one says the other should pay spousal support. That's fairly common practice. I wouldn't put a whole lot of stock into it until I see someone actually file a request for order asking for fees.
Attorney fees.
That's when I think it becomes real. And that wouldn't happen until you know what the financial circumstances are anyways.
Right. And then, well, you just mentioned it. The same thing's going on with spousal support. He asked, supposedly, her for spousal support. And yes, for him. I mean, it's just, if there's nothing, well, what if there's nothing? What if there are no assets left? There is no money left. It's really just a status-only divorce then if there's dust, right?
Well, the focus in the short term would be on the income. And if neither of them have income, neither of them have assets, then yeah, at that point, that kills the analysis. There's no support. I think hypothetically, if Mr. Gerardi didn't have any income and the soon-to-be ex-Mrs. Gerardi did have income, she continues working and going on the show and all of that, I mean, he could make the argument for spousal support. And he could get it in theory. Again, though, the court it's a court of equity. It's not a court of law. So the court is not bound necessarily by black letter law. The court can look at what's fair and equitable. And again, I don't know who the judge is assigned to the case, but, I would say almost every judge in the Los Angeles Superior Court would probably not be eager to give a ton of spousal support to him under these circumstances. I would be shocked. Not that he's going to get nothing, but just giving him a windfall and debilitating her. I don't know. But then again, she may be perceived as equally involved in this. And, to the extent the judge doesn't find her sympathetic, the judge may just say, well, I'm just going to run what's called a Disomaster, at least at the temporary stage, which is this computer program we use to calculate the amount of temporary spousal support, which we call pendente lite support. Judge could just take the tax return, whatever the last tax return is, or the most recent profit and loss statement, plug it in, maybe leave Mr. Girardi at zero, or maybe even impute minimum wage to him, or however they want to do it. And it's going to spit out a number that she would have to pay. So it's a possibility,
Oh, my. Well, we're going to hear more and more and more about this because the bankruptcy isn't totally over and the divorce hasn't really started. But I think this is a really good start for people to understand so many different aspects of a high net worth case or what was previously a high net worth situation, transitioning to something else. It's all fascinating to me. And Matthew, as always, you were great with sharing your information.
Well,
and so if people want to share their cases with you and have you take them, how do people get in touch with you?
So the easiest way is go to my website, smurdalaw.com, SMURDA law.com.
Thank you so much. And for all of you, if you would like to get in touch with me, present a topic, ask some questions, happy to field those. You can reach me through the website for this podcast, Judith at theamicableddivorceexpert.com. Thank you for sharing this time with us. I appreciate each and every one of you. And as always, have an amicable day.
That's our show for today. Thank you for joining us. Be good to yourselves, be kind to your spouse, and cherish your children above all else.